Hello and welcome to AFTO's fall webinar series. I see people are still joining. I'm going to give it just a few seconds and then we'll get started. All right. Hello and welcome to AFTO's fall webinar series. I'm your host, Carrie Rigdon, and this is our first webinar of the series. We are kicking things off with a highly requested topic: the implications of the Loper Bright decision and the end of Chevron deference. We've got two excellent speakers here with us today, but first, a little housekeeping. The session is being recorded, and all of those who registered will receive a link to the recording, as well as a copy of the slide deck in the next few days. If you have any questions, we ask that you please leave them in the Q&A box, and we'll get those addressed during the question and answer portion at the end of our session. We're asking you to use the Q&A tool instead of the chat because that makes it a little easier to see the questions. So now it's my pleasure to introduce our two speakers. Sharon Linden Mayle is a partner at DLA Piper in Washington, D.C. Sharon applies her decades of senior level experience at the U.S. Food and Drug Administration to assist her clients in the areas of food safety, food labeling, product development, imports, third-party audits, dietary supplements, and cannabis. At FDA, Sharon served as a senior advisor for policy in the Office of the Commissioner, playing a leading role in implementing many significant food regulations and strategic initiatives, including the FDA Food Safety Modernization Act. Sharon earned her BA at Cornell University and her JD at Harvard Law School. Joining Sharon is Param Gorgi. He joined DLA Piper in July 2023 from FDA. With more than 20 years of federal service, including nearly a decade of experience as the Deputy Chief Counsel at FDA, Param has extensive litigation experience and a deep understanding of the FDA's regulatory goals and methods of enforcement. Param also has significant trial and appellate experience, having represented FDA and other federal agencies in court while at the U.S. Department of Justice Consumer Protection Branch, and having served as an assistant U.S. attorney for the District of Columbia. Param's expertise distinctively positions him to advise clients in their litigation, investigatory, and regulatory matters. His deep capabilities and a major trial experience in FDA and other government enforcement matters are unique, adding to the breadth of DLA Piper's top-notch FDA team. So welcome our two speakers, and now I'd like to turn it over to Sharon and Param.
Thank you so much, Carrie, for inviting us here today. I'm going to move past these bio slides, which are just in there, for your background. But really, thanks so much for inviting us here to talk about the impact of the Loper Bright decision. While this may not be the topic that everybody talks about around their dinner table, we can assure you that it is the subject of a lot of conversation among legal circles or within legal circles, particularly those of us that practice in the regulatory space. So we're really happy to be here to explain what all that fuss is about. And you can see on the slide what we will be covering today. We thought we'd start by setting the stage and explaining a little bit of Administrative Law 101 to the audience for those that may not be lawyers in the audience. And then we'll talk about the world before Loper Bright. And then, of course, the Loper Bright decision itself. And then we'll end up by trying to help everyone understand what this decision means in the real world and how it might impact federal and state governments, including FDA, but also industry. So with that, and as I said, I'll start with a little bit of basics to help level set the discussion. So many of you may know that the Constitution requires a separation of powers between three branches of government: the legislative, executive, and judicial branches. And the executive branch includes not only what we think of, which is the White House, but of course also the departments, the agencies, the commissions that are responsible for overseeing and implementing so many government programs and statutes. And in general, the three branches can't delegate powers to one another under the Constitution. But the legislative branch can grant some powers to administrative agencies, and Congress often passes legislation that does just that. This is particularly desirable when the legislation involves increasingly complex and technical industries where expertise is vital to the effective governance and oversight of those industries. So the question that we'll be talking about today is where to draw that line in that delegation. Congress essentially has to establish what's called an intelligible principle to govern the delegation. So what does that mean? Well, it means that Congress has to set reasonable legal standards that limit the degree of discretion that an agency has when it exercises that delegation. So it's constitutionally sufficient if Congress clearly delineates the general policy that will be delegated, the public agency which will apply it, and the boundaries of that delegated authority. So all federal agencies essentially get their authority through Congress's enactment of federal statutes. And some of those statutes are very clear and precise, but not always. And that imprecision sometimes is intentional, and sometimes it's unintentional on the part of congressional drafters. Sometimes this legislation gets drafted quickly, goes through a lot of committees, and then things end up maybe not quite as clear as those who were debating it or thinking about this legislation may have wanted. And in many cases, that enabling legislation is just very complex and ambiguous. And sometimes, as I said, given the amount of discussion that goes on in Congress when things are passed, and sometimes not enough discussion, there are internal contradictions within legislation. And as part of my responsibilities, as Carrie alluded to in the introduction, I oversaw the implementation of several statutes through the regulatory process. And those ambiguities and those contradictions can certainly be a challenge, because in the end, an agency just has to use its judgment as to the meaning of the law and anticipate when it does exercise that judgment that this may be challenged in the courts. So when FDA, or quite frankly, any agency, writes those implementing regulations, the agency does so also in compliance with the Administrative Procedures Act, or the APA, which governs the process by which the federal agencies propose and finalize its regulation. And significantly for this discussion, the APA also grants U.S. federal courts oversight over agency actions. The APA requires that federal agencies not act in an arbitrary and capricious manner, and this is why agencies often write extensive preambles to their proposed and final rules that they publish in the Federal Register. Those preambles, along with the administrative record, help explain the basis for the rulemaking, as well as how they consider the public input through the comment process or public meetings, and explains the responses to those comments that they received from stakeholders. So with that, I think I'm going to turn it over to Param to pick up some of the court decisions that around these issues that I just talked about.
Thank you, Sharon, for that overview. And Carrie, thank you to you and the entire association for having us present today. As Sharon just explained, federal courts are charged with oversight and review of agency actions under the APA. When courts review agency actions like regulations and adjudications, a critical question is how much deference to give agencies when there's a statutory ambiguity, particularly when agencies have scientific and technical expertise. Federal courts have to decide what deference, if any, to give an agency in implementing a congressional statute. Before Chevron, courts probed how persuasive the agency's interpretation was. And the Supreme Court case that exemplified this approach was Skidmore v. Swift, a 1944 case that informed courts to give deference based on the thoroughness evident in the agency's consideration, the validity of its reasoning, its consistency with earlier and later pronouncements, and all those factors which gave it the power to persuade. And that means courts focused on the degree of the agency's care, the agency's consistency, the formality, and relative expertise, and the persuasiveness of the agency's position. And that was the case Skidmore v. Swift, which involved a packing plant, the challenge to packing plants' overtime pay for when they were held overtime. In 1984, the Supreme Court provided a different path and provided a formal framework for agency deference in the case Chevron v. NRDC. That case involved a challenge to EPA's regulations interpreting a term in the Federal Clean Air Act. The Clean Air Act was a pro-environmental legislation, but the Reagan administration's EPA seized upon an ambiguous term what is a stationary source, to issue a pro-industry interpretation to the dismay of environmentalists. The Supreme Court found that the Clean Air Act was ambiguous and sided with the Reagan administration's upheld the EPA's regulation. In doing so, in Chevron, the Supreme Court set out a two-step method for courts to review an agency's construction of a statute it administers. The first step, step one, the court was to ask whether Congress has directly spoken to the precise question at issue. And if the meaning of the statute is unambiguous, then the agency and the court must adhere to it. But if not, if the statute is silent or ambiguous with respect to the specific issue, then at step two, the court then asked whether the agency's answer is based on a permissible construction of the statute. And that second step became known as Chevron deference, as it called for courts to resist simply imposing their own construction of the statute, and instead required that courts defer to an agency's reasonable construction of a statute when the statute failed to clearly express Congress's intent. So what is the significance of Chevron? Well, under Chevron, a reviewing court, as we said, was required to defer to federal agencies' permissible interpretation of ambiguity in a statute administered by the agency. And over the last 40 years, Chevron deference became a bedrock doctrine of administrative law, with federal district courts and appellate courts applying the methodology in tens of thousands of cases. The standard, as you can see in this graph provided by the Michigan Law Review, a study by the Michigan Law Review, the standard led to lower federal courts to rule for the government in the overwhelming majority of challenges to agency rules and regulations and adjudications, and upholding administrative adjudications. The application of Chevron deference strongly favored agency interpretations, and studies have estimated that agencies prevailed in more than 3/4 of these cases decided by federal courts of appeals, and that proportion may actually have been higher for federal district courts. So just looking at this chart, the left column signifies wins for the government agencies under Chevron at approximately 75%, and less likelihood of success for the government occurring as lesser standards of deference were applied, all the way to the right being a de novo review. Now, you may have heard that over the past decade, the Supreme Court began sharing its dissatisfaction with Chevron. The Supreme Court actually last deferred to an agency interpretation under Chevron in 2016. But even as the Supreme Court's commitment to Chevron began to wane over the past decade, lower courts were still bound by the decision and continued to apply it. And in my prior job at the FDA, overseeing litigation for approximately 9 years, and at DOJ for another 6 years, we certainly based litigation risk and litigation strategy with Chevron Step 2 in mind. Moving to next slide. So with that backdrop, why are we here today? We're here because of the Supreme Court's new decision this past summer, Loper Bright Enterprises v. Raimondo. And the cases provide a new framework for judicial review of ambiguous statutes. In June 2024, in the Loper Bright decision, a 6-3 Supreme Court majority formally abolished the Chevron doctrine. The Supreme Court held that courts must exercise independent judgment in determining the meaning of statutory provisions, even ambiguous ones. And the regulation at issue in Loper Bright required fishing vessel owners, in some circumstances, to pay for an onboard observer to monitor compliance with federal fishery regulations. The two combined cases in the Supreme Court were the Loper Bright Enterprises case and also Relentless Inc. versus Department of Commerce. These two cases came up to the Supreme Court, and in the lead case is where we got the opinion. In the lead case, Loper Bright case, to give you the background on that case, the district court had granted summary judgment in favor of the government, concluding that the underlying statute, the Magnuson-Stevenson Act, authorized the National Marine Fisheries Service to mandate that fishing companies pay for the observers required to be on the vessels. The company appealed, and on appeal, the DC Circuit found that the statute was silent on the question of whether the vessel owners could be required to pay for a monitor. The court then proceeded to Chevron step 2, where it deferred to the agency's interpretation, which it found to be reasonable. When appealed to the Supreme Court took this as an opportunity to revisit and overturn Chevron, which many folks aware of judicial precedent were anticipating with these cases. The Loper Bright Supreme Court found, first, the Supreme Court found that Chevron was incompatible with the text of the APA, which states that reviewing courts shall decide all relevant questions of law, interpret the constitutional and statutory provisions, and determine the meaning of or applicability of terms and agency action. Second, the court rejected the presumption that ambiguity should be assumed to be a delegation of authority to the agency. Third, the court held that agencies have no special competence in resolving ambiguities, but courts do, even if it happens to implicate a technical matter. Now, this was an issue that Justice Kagan authored a dissent, highlighting her concerns that courts might not be best to resolve ambiguity, especially when the statute is of scientific or technical nature. She was part of the minority. The 6-3 majority opinion cited Skidmore v. Swift, the 1944 case we discussed earlier. And the Loper Bright majority opinion explained courts may still seek aid from interpretations of those responsible for implementing particular statutes, but a reviewing court may find an agency's interpretation persuasive, but not controlling when conducting its own independent analysis of a statute. And it identified factors articulated in Skidmore. Under Skidmore, the agency's interpretation may be informative for the court to the extent such interpretations have the power to persuade, based on the factors we had discussed already. The thoroughness evident in interpretations, the power to persuade based on the thoroughness evident in its considerations and the validity of its reasoning, its consistency with earlier and later pronouncements. At bottom, according to the court, there is a best reading of each statute, and it is the one the court, after applying all interpretive tools, concludes is best. Now, there's one exception in particular, when a statute delegates authority to an agency with discretion consistent with constitutional limits. But even then, the Supreme Court in Loper Bright said that courts must respect the delegation while ensuring that the agency acts within it. Now, the Supreme Court in Loper provided some examples involving the EPA and the Nuclear Regulatory Commission. Just to give you an example in the context of FDA, this came up recently in a past few years with the example of deeming of tobacco products. And in the TCA, the Tobacco Control Act, Congress defined tobacco products and stated that the requirements of the statute applied to cigarettes, cigarette tobacco, roll your own tobacco, and smokeless tobacco, and to any other tobacco products that the Secretary, by regulation, deems to be subject to the TCA. And conspicuously, the statute did not specify cigars, vaping products, and many other products that we would often think to be tobacco products. And they left to FDA to deem those products. FDA did that in its deeming regulation. In that case, that regulation was challenged in court. FDA's decision to deem vaping products to be subject to the TCA was challenged in Nicopure, and the FDA was successful. Sharon, at this moment, do you have any examples that you think would impact the food regulation industry?
Well, I mean, I've thought about this a lot, particularly because I'm sure most of the people on the call know FSMA was obviously a huge change to how FDA was regulated regulated food, and the agency issued several regulations providing the parameters of their new authority and put in things for industry to do. Congress actually established a lot of those parameters in the legislative itself. So I would say that there was clear delegation of authority to FDA, and Congress put in the parameters that FDA needed to follow when they were issuing those regulations. And some of those parameters included what had to be in the regulation. For instance, that facilities needed to consider biological, chemical, and physical and radiological hazards when creating a food safety plan. And Congress also told FDA what couldn't be in the regulation in several instances. For instance, in the food traceability rule, they said, well, FDA can't provide specific technology that industry must use in implementing the food traceability rule. And they also, in many instances, Congress specifically carved out exemptions for certain categories of food producers for certain of those provisions. So I would say in FSMA, a lot of that delegation was quite clear and had strict parameters around it. That doesn't mean that there won't be challenges in certain instances, because obviously Congress can't pass an act that has every little detail in it. So it'll be interesting to see. But I would say FSMA had a lot of clear delegation and a lot of restrictions on what FDA could and couldn't do under their rulemaking under that statute.
Thanks, Sharon. So what does Loper Bright mean? This is, obviously a case that we're going to be hearing about a lot. It's going to be getting cited in almost all administrative law cases in the next many years. What does it mean? A reasonable agency interpretation of statutes set forth by regulation will no longer be granted a presumptive pass if the statutory language being interpreted is found to be ambiguous. And instead, a reviewing court should independently interpret the statute and effectuate the will of Congress, subject to constitutional limits. So one question is, does this apply to prior cases? The Loper Bright court explained that its overruling of Chevron deference does not apply retrospectively. The cases that were decided in reliance on the overruled Chevron test remain good law, entitled to statutory stare decisis, despite the court's change in interpretive methodology. However, the demise of Chevron will at the very least make it easier for litigants to challenge interpretation of ambiguous statutes, potentially including those that have previously been upheld in other cases by other litigants in other courts. And this is an important point in light of another Supreme Court decision that came out this past summer. In Corner Post, Inc. versus Board of Governors of the Federal Reserve System, case that was issued in July 1st, 2024, the same 6-justice majority ruled that the default 6-year limitations period for APA challenges begins to toll when a particular plaintiff is injured by the agency rule, not 6 years from the agency action itself. What does this mean? What it means is that newly affected parties can bring modern day suits under the new Loper Bright standard. In practical terms, Loper Bright, along with Corner Post, can be expected to open challenges to decades-old regulations and agency decisions. Now, just as a quick note here, Corner Post precedent doesn't not apply where more specific statutes provide a shorter period of time to challenging agency action. So statutes often will say that there's a limit of time and that the APA default does not apply, like the 60-day provision governing challenges to certain FDA orders involving food additives. Moving to slide 10. So we think that the court's ruling will have major implications for the operations for the branches of government. We're going to look at each of the branches, the executive branch, the judicial courts, Congress. We're also going to look at the states. And focusing on the executive branch, and in particular agencies, as a result of Loper Bright, we expect that agencies will be defending more litigation. Loper Bright will likely increase the likelihood of success of those challenging federal regulations and adjudications. And Loper-Bright will limit executive agencies' ability to fill in gaps in the law or to address situations not expressly anticipated and addressed by Congress. It may cause agencies to proceed more cautiously and narrowly in adopting regulations. And without a doubt, agencies will be spending more time and resources to provide justification for their decisions. And as Sharon already explained, based on her tenure at the agency, FDA already spends a great deal of time and is meticulous with administrative records and extensive preambles. Looking at the courts, Loper-Bright shifts responsibility for interpretation of federal statutes from the executive agencies to the judicial branch. Specifically, Loper-Bright charges courts with supplying interpretation of ambiguous statutory provisions, even where technical and scientific expertise may be implicated. And there will be significant questions are likely to arise as courts' capacity to adeptly interpret the law in specialized scientific areas absent clear and specific congressional direction. And this may require the use of additional judicial mechanisms, such as the appointment of special masters. We may see a proliferation of that as courts are required to take the determinative interpretation. And certainly, there is going to be less uniformity in the law. With approximately 850 federal judges, there's likely to be more disagreement, and the Supreme Court is going to have to address more splits. Sharon, what are your thoughts on Congress and also the states?
Yeah, thanks, Param. So, when you think about the legislation that Congress passes, and so many different areas in the complexity of what is the regulatory administrative state in the administrative branch, I think that Loper-Bright's going to put a lot of pressure on Congress to legislate with even a greater deal of specificity in an effort to avoid having courts give their own meaning and interpretations, or at least I think that they'll include more express authority for the agencies to interpret legislative language where that is permissible. And given how complex some legislation is, Congress is going to have to figure out how to get that needed expertise, right? Because when you think about the staff of senators and representatives, they may not have the expertise in every area in which they choose to legislate. And that's, particularly true with issues that are technical in nature. And of course, many FDA issues are very technical in nature. So I think sometimes that could mean hiring staff with that expertise. When I was at the agency, well, when both Param and I were at the agency, there were often FDA staff that took details with various congressional staffs that could help provide some of that expertise in the agency or in a scientific area to help Congress draft and draft legislation. But it also, I think, means for Congress that they're going to be using external experts for input, and that can include lobbyists. And it also could include soliciting input from actual agency staff. When agencies can't lobby Congress for particular provisions, they can provide what's called technical assistance when it's requested. And I know when I was at the agency, I personally briefed members of Congress and their staff as they were developing legislation and provided agency comments on legislation, including FSMA and MOCRA for cosmetics. So, I think Congress is going to need that expertise to address many issues. And this wouldn't just be for FDA, right? This is going to be across all federal agencies. And so they're going to have to get that expertise somewhere. Now, for states, I think given this audience, it was important to talk a little bit about what Loper-Bright is going to mean for state regulators. And I think, taking this a little step back and to FDA, I think from a rulemaking perspective, Loper-Bright could indeed have a chilling effect on the agencies that are issuing those regulations. And when FDA doesn't issue regulations and there is concern about issues, there's it's sort of an increased incentive and opportunity for states to advance their own regulatory initiatives in the absence of FDA action, of course, assuming there's no preemption in that area. I think one thing that's just not as clear is how the Loper-Bright decision itself is going to impact state courts that may have previously adopted sort of a Chevron-like deference in adjudicating challenges to state agency action. So I think it's an open question as to whether state courts will also reverse track and reach a Loper-like decision in rejecting deference to state agency action. So I think that's something to look for in the future. This is already a trend in the states the last 20 years or so. Many states have already adopted, state courts have adopted a de novo review in place of deference to state agency actions. And other states apply that Skidmore deference that Parham described earlier. So I think the Loper-Bright decision might encourage that trend to continue.
Thank you, Sharon. So just thinking about Loper-Bright and how will this new paradigm under Loper-Bright impact FDA? And just to put this into perspective, statistics have shown that FDA, like other federal agencies, benefited from Chevron. And that was certainly true when I managed litigation for FDA. And just looking at the statute that FDA oversees, the FDCA, the PHSA. These are statutes, like many federal statutes, that are very complex and complicated. So there is no surprise that there are many opportunities to have to fill in ambiguities. In the 10 cases where the courts of appeals relied on Chevron, meaning that they actually applied step 2, finding the statute ambiguous, all sided with FDA as reasonable. The district courts were also bound by Chevron. So that just helps you understand how important this was to FDA. After Loper-Bright, there will be some FDA interpretations that will likely be ripe for challenge as a result of Loper-Bright. And areas likely to have vulnerability for FDA include product jurisdiction issues, exclusivity determinations. And there are also some overlap for product approval. Looking at product jurisdiction, just to give you some examples, for lab diagnostic tests, LDTs, the assertion of authority to regulate LDTs, laboratory developed tests, as medical devices has already been challenged. A lawsuit was filed by the American Clinical Laboratory Association against FDA in the Eastern District of Texas. And it's going to be probably one of the first FDA-related cases to be decided under Loper-Bright, and maybe the pending challenge to FDA's authority to regulate LDTs as devices. The plaintiffs there claim that the definition of devices is unambiguous and that devices are physical products, not services such as lab testing. So that's something to keep an eye out for, and we'll see how the briefing unfolds. Other issues that are jurisdictional issues, such as whether or not a product is a drug versus a dietary supplement. This was something seen in the Whitaker v. Thompson case in the DC Circuit in 2004 on whether or not FDA may regulate saw palmetto extract with disease treatment claims as a drug instead of as a dietary supplement due to the statutory overlap in the definition of health claims and drugs. There, the marketers sued FDA challenging the agency's determination that the marketing of their dietary supplement containing saw palmetto extract was a health claim that could be regulated, and the FDA claimed that it could be regulated as a drug. FDA's denial of a classification petition followed by a public hearing and comment was an adjudication where FDA required the extract must first be approved as a drug because it made a claim that the product could treat a disease. The court found an expressed intent, but the court found that the expressed intent of Congress was ambiguous and subsequently turned to FDA's rationale to determine the reasonableness. And the court upheld the classification that certain types of health claims are drug claims, finding it to be reasonable statutory interpretation, and dismissed the plaintiff's claim. Now that's a case with a different standard without Chevron that could be decided differently. Also, product jurisdictional definitional type issue is now seen in a more recent case, whether or not a product was a drug versus a biologic in the recent case, Eli Lilly versus Sarah, Eli Lilly's diabetes treatment, retatrutide, the question is whether or not it's a biologic, as Eli Lilly claims, or a drug, as FDA decided. And it really turns on how is a protein defined by FDA regulation and which amino acids to count in determining whether or not it's a protein and thus regulated as a biologic. Another area where we think this will come up as in a jurisdictional type issue will be clinical decision support software and FDA's narrow interpretation of the exclusion from the device definition that was amended by the 21st Century Cures Act, and whether certain software can be regulated as a device. A whole nother area, aside from definitional issues under the statute, where Loper Bright is likely to have a clear impact, are exclusivity determinations. For example, whether or not something, orphan drugs or generic drugs, can avoid competition for a period of time. About half of the Chevron cases are these types of exclusivity determinations, where a lot of money is on the line for sponsors and generic manufacturers. Some examples are the Ixuca case from 2017, where the court determined that FDA reasonably determined that a pioneer exclusivity is only infringed by a drug with the same active moiety, interpreting that from the statute. Another matter, the AstraZeneca case from 2013, where FDA was said to have reasonably interpreted the FDCA's exclusivity provision for a change approved in a supplement not to apply to the addition of warnings or other similar risk information. Then a whole nother area to think about are product approvals, and that's an area where the impact with Loper Bright is less direct. The APA's arbitrary and capricious review standard governs agency fact-finding. So to put this into perspective, a case, the Cytori Therapeutics case, was a case in 2013 where FDA denied a 510(k) clearance application of a device for harvesting cells. Cytori, the company, argued its device was substantially equivalent to devices already cleared for harvesting cells from blood and bone marrow. And Cytori had provided data from 12 donors to show equivalence. The FDA concluded that the device was not substantially equivalent to its predicates. Cytori's intended use, harvesting cells from fat, FDA said was different than the predicates harvesting cells from blood. And the enzyme used to separate cells out of the fat posed a new safety question. FDA also said that Cytori's study was too small. FDA's non-substantial equivalence decision denying the 510(k) application was upheld by the DC Circuit. And of note, this opinion was given by then Judge Kavanaugh of the Court of Appeals, now Supreme Court Justice. Judge Kavanaugh at that time noted, "A court is ill-equipped to second-guess the kind of agency scientific judgment under the guise of the APA's arbitrary and capricious standard." So this is a different standard than statutory interpretation at issue in Loper Bright. But the question still remains and will still be subject to debate about whether when there are mixed questions of law and fact. And for example, the drug approval process requires adequate and well-controlled studies. And there may be a denial based on the understanding of what an adequate and well-controlled study is. Labeling questions also come up in the approval process and what constitutes adequate directions for use. Sharon, any thoughts on Loper's impact on the food program?
Yeah, I think there's likely going to be several examples of agency interpretations that are going to be vulnerable for challenge under this new framework. One thing that comes to mind is the drug preclusion provision that excludes certain active drug ingredients from being added to dietary supplements as well as some foods. And this comes up a lot in the cannabis products area, sort of what is an active drug ingredient that triggers this exclusion. And some of you may be familiar with the Pharmanex case that ruled on this issue with respect to a product that is called Colestin. Colestin was made out of red yeast rice and was marketed as a dietary supplement that was intended to promote healthy cholesterol levels. But the natural substance in the red yeast rice case, I always have to be careful when I say that, it's hard to say, that had that effect was chemically identical to an active ingredient in a prescription drug called Mevacor. And FDA took a broad view of what constituted an active pharmaceutical ingredient and determined that colistin fell outside of the definition of a dietary supplement because of this active ingredient. And the 10th Circuit, which is the Federal Court of Appeals, upheld FDA's decision because it said the statute wasn't clear. And there are many, I think, who would like to challenge that decision at the Supreme Court level to narrow the drug exclusion provision, particularly in the cannabis space, where FDA has excluded CBD from being in dietary supplements. Another area that might be vulnerable to challenge is the GRAS notification process. There was a federal district court case in 2021 in which the Center for Food Safety challenged FDA's rule that codified FDA's practice of allowing any person to notify that a particular use of a substance in food is GRAS. And the court found that FDA's interpretation to be a reasonable interpretation of the FD&C Act and upheld FDA's use of the voluntary GRAS standard for food additives. Beyond challenges to particular agency decisions, I think that there are other impacts to FDA and other regulatory agencies, and we've talked about some of them, but I think we, need to think about the resources that it's now going to take to issue rules, because the agency is going to take even greater care to justify its rulemaking decisions. And in addition, we talked about the extensive preambles and the administrative record that FDA already puts into play when it's making when it's issuing rules. I also think the agency is going to have to devote additional resources, and Param is certainly an expert in this, to defend past interpretations of the statute when they are being challenged. And then we also talked a little bit about the chilling effect that this could have on agencies that cause them to be less ambitious, particularly with regard to assertions of authority, which is beyond what's specifically outlined in the statute. I was actually at the agency when David Kessler was commissioner, and he decided to take on the tobacco industry by issuing a rule that deemed cigarettes to be drug delivery systems. And many of you may remember that. It ended up leading to the passage of legislation that gave FDA explicit jurisdiction over tobacco products. But those of us that are a little bit older remember, and some of us worked on the regulation where FDA tried to assert that jurisdiction, by looking at all of the authorities that FDA had, and again, determining that cigarettes were drug delivery systems. Those are the kinds of ambitious rulemaking that I think this will certainly have a chilling effect on. But of course, I think it could have a chilling effect even beyond that. And I think and I know a lot of people complain about the FDA rulemaking process and how slow it is, but I think this might even slow it down even more, because the agency is going to want to really cross every T and dot every I to ensure that if a position is challenged, that it's already been thoroughly vetted, assessed, and documented. So I would argue that, as I said, FDA's preambles are already quite detailed, and that agency reviews and its response to comments already take a really long time for the agency to get rules out. Loper Bright may require even more scientific justification and factual justification to explain the decisions going forward. And finally, I think we wanted to just mention that the agency may be inclined to find alternatives to rulemaking by relying on other tools in its toolbox, like guidance documents or enforcement discretion policies. So I think really we don't know all of the impacts that this is going to have on agencies, but I think it's pretty clear that it's going to have an impact on FDA and other agencies. So I think we'll see as the years continue exactly how that's gonna roll out. Finally, I wanted to talk a little bit about the implications for FDA regulated industry. And in many ways, this is a little bit the flip side of what we've been talking about, but it's all really talking about these same issues. So we discussed that there could be, a greater likelihood of success when industry wants to challenge agency decisions, especially for those where Congress may not have clearly delegated either expressly or in an implied way authority to FDA. And as Perrin talked about, given the corner post decision, there's even a greater opportunity to challenge past agency decisions. But reduced judicial deference to agency interpretations is likely to increase regulatory uncertainty. And that's not always a good thing for industry, because FDA-regulated businesses often rely on FDA regulations to make their decisions on a day-to-day basis, as well as longer-term planning. And this post-Loper Bright world that we are now living in will limit the ability of businesses to confidently rely on agency pronouncements. And finally, I guess I'll add that given the importance of legislative language going forward, the Loper Bright decision may provide increased incentive for FDA-regulated industry to influence Congress to provide additional detail to decrease that ambiguity that could allow for agency interpretation that may be subject to challenge. So you may see, a lot more involvement in the legislative process. When I was at the agency, we would sometimes be quite surprised at sort of the level of specificity in particular provisions, and you just knew that it was because someone really cared about that provision. So I think there'll be an increased incentive for industry to get more involved, and not just industry, quite frankly, all stakeholders, to get more involved in the legislative process to try to influence that language and leave less ambiguity for FDA and other agencies to work with. Perrin, I'll pass it back to you.
Thanks, Sharon. So given this new paradigm with Loper Bright and corner post, it's important to think through deciding whether or not to challenge agency action to be on the affirmative, and what considerations would inform that decision. It's really important to start by first thinking about what your objectives are, and can they be accomplished without litigation? There are certain downsides to trying to challenge the agency, particularly when you have an ongoing relationship with an agency as a regulator. So thinking about what are the consequences of doing nothing, if it's something that you can live with, does it not create a competitive disadvantage? What are the anticipated benefits if you prevail? Also, what is the likelihood of litigation success? And again, we have tried to explain that there are certain instances, certain types of issues that the agency will be more vulnerable, and others, including approval determinations, which require fact-finding, where the agency is still likely to get arbitrary and capricious deference review. Also thinking about what are the legal and regulatory risks of taking on the government. As we mentioned, you have an ongoing relationship with the regulator, and they are humans over there, and even though we would like to have emotions separated from regulation, agencies do have views of industry actors and have certain views of whether or not they consider the company to be a responsible company, or ones that are always trying to push the envelope. And are there adverse implications for the relationships with your regulator and also customer base? And then what are the public relation considerations? And also think about whether or not it's necessary for you in particular to take on this fight with the agency. Is there somebody who can act as a proxy, a trade association, someone else to challenge the agency? That often is the way in which agency action is challenged. But we do think that there will be, as a result of Loper Bright and corner post, significantly more opportunity to try to overturn agency action going forward. And also, as we mentioned, taking a second look at prior decisions, regulations. Again, as the Supreme Court said, those cases are starting to cease. Can't overturn those cases, but not all cases, not all regulations have come up to the Supreme Court. Some of the, like as we said, some of these have been decided at the Court of Appeals level. There are many other courts of appeals out there. There are others. Fifth Circuit is one that many litigants try to get in front of so that because they believe the Fifth Circuit is likely to overturn government agencies' decisions. So those prior decisions can be revisited by new litigants in new courts when those cases never made their way up to the Supreme Court. Sharon, any concluding thoughts?
No, I think that does about that's about it for going through our slides. I know that we wanted to leave a little bit of time for Q&As. I see a couple in the chat, and I'm happy to kick it off by maybe throwing one at you, Param, for those of us that are. I'm sorry, Carrie, did you want to step in? I see that you just jumped on. Did you want to?
No, go ahead. Go ahead.
Oh,
I'm
okay.
just happy to read out some of the ones in the Q&A as well, but go ahead.
I did see one that had to do with standing. Maybe if someone could read that, and then I
Yes, thank you.
answer that
So,
one.
does Loper Bright affect standing? So some class action lawsuits on levels of inorganic arsenic in infant cereal dismissed the suit against Gerber because only FDA has standing to determine what arsenic levels are hazardous. Would this dismissal no longer be possible in the future due to the end of Chevron deference?
That's a really good question, and obviously it's very important for industry and state litigants, private litigants, trying to figure out when there's an opportunity to bring a lawsuit versus having to wait for FDA to make a determination. So I think that the question had used the word standing, but I think this is more really an issue of primary jurisdiction and preemption. And I think those are other constitutional principles that don't specifically have to do with ambiguous statutory interpretation. But those will be ongoing issues with respect to whether or not the FDA has made a specific pronunciation about an issue. Now, if because of Loper Bright, FDA is less likely to fill in the gaps, then there might be more opportunities for private litigants to bring their own cases and avoid arguments that FDA has already spoken on the issue. And then just separately, just touching on the issue of standing and whether or not somebody can bring a lawsuit based on constitutional questions of harm and causation. These are constitutional requirements that courts will have to address in cases, even if the statute is crystal clear and does not have an ambiguity. Now, there will be some instances where Congress has passed a statute specifically on the issue of who may bring a lawsuit, standing issues. But I think those are not issues that are likely to be delegated to an agency to decide, and courts will likely be interpreting provisions probably in a pretty straightforward manner, as they're not likely to have scientific and technical provisions in those types of statutes.
Yeah. I'm sorry.
I said, I hope that was helpful.
It was. Param, I wanted to just, for those that may be watching this that are not lawyers, I think when people think about Loper Bright, they think about it in the rulemaking context. And I was wondering if you could help explain that this isn't necessarily just rulemaking, that there are other types of decisions that Loper Bright affects. And I do think that you talked about it throughout your remarks, but I was wondering if maybe you could just remind folks that this isn't just about challenging rules.
Absolutely. And that's a really good question, observation, because sometimes people do think that this really has to do with rulemaking. But Chevron, just think about, when did Chevron apply? And Chevron applied to formal rulemakings for statutes that were Congress delegated to the agency, but also in adjudications. So these types of processes where Chevron would apply. Now, if there was something less formal, for example, issuing of a guidance or just an ad hoc letter from the agency, Chevron was not supposed to have applied to those circumstances anyway. It should have been a lesser form of deference, even when Chevron was good law. But Certainly adjudications is another area. For example, a determination to suspend a license, which is party specific, but may turn on interpretation of an ambiguous provision in the statute. That is where courts would have applied Chevron and at this point are no longer permitted to. Courts have to make the determination of what the statute means. And one case that, just as an example that we talked about earlier, was the Whitaker v. Thompson Saw Palmetto case that involved the distinction between drug versus dietary supplement. That was actually a classification petition submitted by the company to get classified as a dietary supplement. And that was not handled through regulation or rulemaking. That was an adjudication. There was a hearing. Then the agency considered comment after the public hearing and then made its decision. And then that decision was subject to judicial review in the DC Circuit. And the DC Circuit applied Chevron in that context. At this point, and again, an issue where if someone else were trying to market that similar product, they could try to take a crack at it in a different jurisdiction and ask the court to not apply Chevron at this point and perhaps get a different outcome.
Yeah, and I think the Pharmanex case, I don't remember all the details of it, but I do recall that was an import decision. But again, someone challenged it and then it ended up in court. So there was an adjudication of it. But you can see that the implications of Loper Bright aren't just about rulemaking. And there are lots of decisions that get made that maybe weren't challenged at some point, but maybe people are going to want to challenge because now they have a different standard of review that this case brought to the agency. I do see one question in there from Michelle. Hi, Michelle. Which is one challenge of FSMA is how and where Congress drew the line between which operations would be covered by the preventive controls rule versus the produce safety rule, specifically whether an operation is a food facility or a farm. Rulemaking to further clarify what is or is not a farm is still ongoing. The complexity and diversity of operations that exist may not have been anticipated by Congress. I think you're asking, what that is. I mean, I think, look, as I said, FSMA was very specific in terms of parameters and what needed to be delegated, but a lot of FDA's rules are mixed questions of law and fact, and as when it comes to fact finding and those kinds of things, that's still under the arbitrary and capricious standard as Param talked about. So it just remains to be seen. You'd have to see the rule. I don't know that I can make any prediction about it, but remember that FDA still has a lot of discretion with respect to fact finding. It's those interpretations, the statutory interpretations, where that are going to be more ripe for challenge. So I don't know if that fully answers your question, Michelle, but try to at least shed a little light on that. I don't know where we are. Looks like we are about at time, so I don't know.
Yes, we are. In fact, we're a little over because we want to give people time to go on to their next thing they have today. But I want to excellent questions, and I want to thank Sharon and Param. Great presentation, and thank you for kicking off our fall webinar series. Just a reminder to all you out there, please keep an eye out for a post-webinar email. That will include access to this recorded session as well as a PDF presentation version of the presentation and any additional resources. And also remember to check out the rest of our Fresh Take Fridays. I will put that in the chat. We've got a great lineup, so check that out. And with that, thank you, everybody, and have a great Friday.
Thanks so much for having us. Take care.
Thank you.
Have a good weekend, everyone.
Thanks.